Alex here with part 71 of the My Docket series on child custody and visitation. As with my previous videos, I'd like to take this opportunity to direct my viewers to part 0 if you haven't seen it yet. That's the video that contains the detailed disclaimers and the underlying purpose of the series. Two things that I will glaze over are, number one, I'm not in the middle of this right now. My case is completely and totally over. It's closed. It cannot be reopened, and that's because my ex's parental rights have been terminated. Number two, the nutshell version as to the purpose of the series is to give my viewers one big example of my 8-year-long high-conflict child custody ordeal from beginning to end in chronological order. So straight into this one, I get an attorney for the first time in all of these filings. I think I'm well over 100 filings by now, a few years in, and I got an attorney to help me out. And this was an attorney that I worked with at the collection agency that I was working at. This is actually the same collection agency that triggered a filing by my ex of a motion to modify child support. I told him, I would appreciate some help. I'll have all the paperwork done and ready. All you're going to have to do is just appear at a hearing and argue just, at the evidentiary hearing in front of the judge. And I always thought that this would be one of the only ways that I could really afford to hire an attorney, because one of the things that you can get around when you're representing yourself is the paperwork. But when you get into court, it just sounds better to have somebody who is not you arguing on your behalf. And I can't do it all the time. As you've seen, I've gone through several hearings alone. So it's not like I do this every time. It's just this is a particular situation where I had, been working with an attorney. We've been going to court together to, litigate these collection agency cases for some time. And I just kind of said, hey, I would appreciate if you can help me with my child custody case. All it is a dispute over education. There's no custody issues at stake, no legal, no physical custody issues, no child support, none of that's at stake. It's just timeshare and which school. And he was pretty happy about offering to help because he needed some help picking some weeds at his house. He had a pretty big house and it was kind of overgrown. And it wasn't even just me. He had 2 other people that were helping as well. I'm not sure if they were just friends or if they also needed help in court, but I think they were just friends. Anyway, he did go to court for me, so you guys are going to get to see a hearing video coming up very soon. In fact, it should be the next video, and you'll get to see this attorney representing me in court for free, which is nice because, I don't even think I mentioned that. I was talking about being able to afford an attorney for this type of situation, and I do end up hiring one for another contentious hearing a few years in advance from where we're at right now in the series. But this particular situation with this particular lawyer at this particular hearing, he represented me free. And I don't know what else I have to say about it except that it felt, I don't want to say good. I was less nervous. I felt like I would get treated more fairly by the judge. At this point, I felt like I was getting a little bit of self-representation bias because of the number of filings. And again, when an attorney files 10 documents, that's a lawyer, that's what they do. When a non-attorney files 10 documents, shame on you. And so to have an attorney going into this hearing, I felt was going to be it would smooth over some of the, in my opinion, it would smooth over some of the short-sightedness of this particular judge when it came to dealing with serial filings and high conflict cases. So I suppose at this point we can go ahead and take a look at what I filed. Here we have the petitioner's hearing statement. This is, I don't know why I called it this. I'm not sure if this is even required. I have heard of memorandum, what do they call it? Pretrial memorandums filed before a trial. I suppose it makes sense that something like this would be filed before an evidentiary hearing. Maybe it's an optional thing, maybe it's not required, whereas a pretrial statement is required. So I just called it my hearing statement, and I don't really regret filing it, but at the same time, I wonder if it contains anything new. I wonder where I got these factors as well. I probably pulled these criteria, like for example, issues and supporting facts. There's probably more of these we're going to go throughout this document. I probably pulled those from the rules of civil procedure on the pretrial statement, But, I mean, I'm just kind of guessing because it's been so many years since I drafted this document. This is way back in 2011. And by the way, even though I mentioned earlier that I get an attorney's help, he has not filed his notice of appearance yet. You're going to get to see that in the next document. So this one was prepared by myself, just me. And in the first paragraph, I identify myself as the petitioner and indicate to the court that I am representing myself by stating I'm appearing in proper person. This is a hearing statement with regards to the hearing scheduled July 21st, 2011. So issues and supporting facts. We're talking about Coral Academy versus Roland Elementary. The first fact that I assert is that it's a charter school, that I actively entered him into the selection process, and when selected, I enrolled him. And I also indicate that Roland Elementary is a public school. Second assertion is that I consulted with my ex on his education before, during, and after enrollment of Coral. She only discussed her proposal after the filing of a motion, and that could not be underlined. Well, I guess it could have been underlined more boldly by putting it in bold. That is one of the most important, I think, things to point out, because that's not normal. That's not the time to start talking about an issue after an opposition is filed. That's like, it just speaks for itself. Next page, we have Coral is half a mile from our exchange location, and Roland is 8.5 miles to the northwest. Coral is also very close to both her place of employment and my place of residence. Looks like she's alleging that the school has 6 recorded incidents, violent incidents, and Roland is attached as Exhibit 2 for comparison. I'm holding that the school is separate from the middle and high school and that it has 0 violent incidents, and I'm mentioning an affidavit on file by the executive director. I'm mentioning that Coral is a charter school, requires active parental action to get involved. Roland is a public school and doesn't. I am asserting that Coral is an academically superior school to Roland, and in support of this, I have Exhibits 1 and 2, which is indicating Coral is listed as high achieving and Roland is merely adequate. I also have the newspaper clipping that I've been talking about. So this one, it says Reno Gazette-Journal, but I could have sworn it was Washington Post. Maybe it was just a Washington Post poll. So we're going to go ahead and take a look at that because that's Exhibit 3. Next, we have a personal reference on file as an affidavit from Ms. Zamala alleging that her daughter has excelled at the school. Timeshare modification, which is the second thing that we're looking to do. First, we have near identical proposals with her requesting a sliver of time on Thursday. And this is what I refer to commonly as the gap of time. I'm trying to close that gap, get rid of it. Child support arrearages. So I could go over this, but I know that the court's not going to do anything about it, so I don't want to waste all my viewers' time. If you'd like to take a look at this and you have questions, go ahead and download the document by going into the description below, clicking on the link, and post something down in the comments. But again, the child support arrearages are not addressed at the hearing, and if they are, it's not like the court enters an order. He might just scold her or something like that. They do get addressed, just not yet. Medical, vision, educational, therapeutic appointments. She has invited extra persons into each and every single appointment. Again, this is one of the things that I brought up at the extra issues to resolve, so I'm going to skip it over. This also does get resolved later on with another filing. So since I'm going to file something to deal with these issues later anyway, we can talk about those issues later when they actually come up. Costs are allowed in actions of equity at the discretion of the court. I'm actually not sure if this is true. From what I have heard, costs are not allowed unless a statute, rule, or contract allows them. So I think this is wrong, and I would have needed to cite some authority. So I'm not citing any statute, any case law. I'm not sure where I'm getting this from. This is most likely wrong. By the way, I don't get an award of costs here. I do eventually get some cost awards against my ex, but it's not now that this occurs. It's later on that it occurs, and I do cite to a statute to get them. Here we have her allegation. Oh, so this is all the cost. If I'm going to skip this. Attorney fees. So she's moving for attorney fees. She bears a burden of proof, and it's necessary for her to both prevail and prove to the court that I brought the motion with the intent to harass. Since I end up winning the motion anyway, we don't even get to that point in the analysis. Undisputed facts. We agree to a timeshare modification, but we have different proposals. I want the child to attend Coral. She wants the child to attend Roland. Legal analysis. Costs are allowed at the discretion of the court. Okay, so there is a case that I've cited. There is a case, but this is with the breach of contract, not in equity. The statute provides for the allowance of costs for the recovery of money damages where a plaintiff recovers, so that's money damages, it's mandatory and it is not subject to the trial court's exercise of discretion. So that's the Supreme Court citing one case here and another case here. If the action were won in equity, an award of costs would be discretionary with the trial court. Okay, so maybe I'm right. Under McGee et al. V. Whitaker, it appears that in equity actions, you can get a cost award. It's discretionary with the court. I would need to take a look at that case though, because I still might be wrong. That case is from 1939, and it's possible that 1939 case is because of some statute from way back when that might not be around anymore. So there might be a statute or a court rule that allowed the recovery of costs in that case that doesn't exist anymore. So I'm probably still wrong. I'm not going to take a look at it because, well, we're in 2020, not 1939, and there's just no point to it because, my case is completely and totally over. I'm trying to get everyone sort of thinking cap on and not so much telling everyone exactly how the law works. Attorney fees, even if granted, can be mitigated. This is true. This is a case called Bergman v. Voice, which talks about how even if somebody does win, and even if the court does show that they are prosecuting an action without a reasonable basis or to harass the other person, you can still actually pick it apart and only impose fees and costs for the portions of that action that were brought without reasonable grounds. And what the Supreme Court is saying in Bergman v. Voice is that the court can't just find one ground and just hit them with attorney fees on the entire case. If it seems like that particular attorney or party litigated most of the case meritoriously, and it's just certain portions of it that were groundless, then the court should just be imposing fees and costs on those portions alone. Child support is owed for March 2011 and April 2011. Again, this is not something we can talk about right now. I will deal with the child support issue. I will get a judgment on arrearages. All the things that I'm asking for, I will get, but I won't get them until later. List of summaries and schedules. Let's see what this is. Oh, so yeah, I'm supposed to apparently attach a list of summaries and schedules because the Second Judicial District Court Rule 50 subsection 1. And they mentioned some kind of court-approved form, but I asked around and nobody knew what I was talking about. So it's one of those situations where the court rules mention a court-approved form, but no such form exists. And so the best I could do was just attach a memorandum of costs as Exhibit 5. But again, this goes to my recovery of costs, which is just not going to happen. Witnesses. So I'm listing my witnesses here, and this is one of the things that you're supposed to have. It's a pretty big deal. My understanding is that if you don't list witnesses in advance, you don't get to call them at the hearing. There is an exception, I believe, for what they call impeachment witnesses, but I don't really know how that works. Anyway, the first one is me. I'm a party. Second one is my ex. She's a party. The third one is Ms. Zamala, who prepared the affidavit. And the fourth one is Yilmaz Ak, who prepared the other affidavit. Comments suggest. By the way, this is what I was talking about. These sections, like list of summaries, witnesses, comments, suggestions, and information. These things, I didn't just kind of pull them out of thin air. They're mentioned in the Rules of Civil Procedure as what needs to be inside a memorandum. So she has cloaked her address under NRS 217.462. It remains in controversy and is filed in case number 56169 of the Nevada Supreme Court. That's going to come down soon. There's a decision coming very soon. I think it's 2 videos away. The next assertion is that she attempted suicide early in his life and spent 3 days at West Hills. And the next assertion is that we concurrently and independently handled a review and modification of child support. The modification was successfully stipulated to. We have an appeal to the Supreme Court regarding delegation of parental duties that was resolved and closed because the duties were not delegated between the parties. Authority remains with both parents, and as a consequence, this educational dispute required litigation through the court. And that's true. I tried to get the court to split up these duties. The court refused to do so, and in failing to do this, now we have to go to court to deal with them anyway. So if he would have actually granted that motion, we wouldn't even be in court. So that's just what I was talking about before with the importance of these judges getting a clue and figuring out that they need to become oriented to minimizing conflict between parents, not forcing them to get along when there's a high conflict ex that won't get along because of mental health issues or emotional immaturity issues. So anyway, exchange of documents. On July 5th, I provided my ex with an email from a Coral representative, and I attached accountability reports for both the Coral Academy of Science and Roland Elementary. On July 14th, I provided my ex with affidavits. On July 15th, I provided my ex with another affidavit by mail and facsimile. Then we have the certification of conference and attempted settlement. On July 16th, I sent an email to my ex to offer to meet and confer. And on July 18th, I contacted her by phone call offering to meet and confer and settle. These are required under the rules. All I had to do was try to do this. I didn't have to succeed. So I sent my ex's attorney a couple of emails. She probably didn't even respond to me, and that's that. The rule was complied with, and I'm letting the court know that the rule was complied with. Declaration. I don't know if this is required. I guess so. Any of the assertions made here, any of the factual assertions, are now supported by an affidavit or declaration in lieu of affidavit. That's not right. So this is wrong. This has to have either a notary stamp, which makes it an affidavit, or it has to have that sentence at the bottom that states that this is under penalty of perjury in the state of Nevada. It has to be verbatim. What is it called? It has to be verbatim. The statement has to be verbatim. And what I'm talking about, you can learn about if you watch the video, affidavits and declarations. In that video, I talk about a statute we have in Nevada that allows you to use a declaration in lieu of an affidavit if you comply with certain requirements. And I didn't do that here. So this was all, I think this is wrong. I don't think this was taken care of correctly. Affirmation, which indicates to the clerk of the court that there's no social security number in this document. A certificate of personal service, which indicates to the court that I personally went to my ex's attorney's law office and physically gave one of our workers this document. We have 1, 2, 3, 4, 5, 6 exhibits. Let's go ahead and take a look. Roland Elementary. This is a school accountability summary report. I feel like it's something like this I'm going to glaze over. You're going to get more interesting debate on this when we actually get to the hearing in front of the judge. So I'm not going to nitpick this or pick it apart. If you guys have any questions, as I've mentioned earlier, you can just go down in the description below, click on the link, download this document, look it over for yourself. And again, if something jumps out at you, you're curious about it, go ahead and post it down in the comments. But I'm going to move through this very quickly. Demographics, yearly progress, parent community involvement. It's all good stuff to read about. But Exhibit 2, it looks like another accountability report. It's probably for a different year. Same thing, guys. I'm just going to move straight through this. It's going to be much more interesting when we get to the actual hearing. Exhibit 3. Okay, here's the article. Reno Gazette Journal. So it was a Reno... Okay, and yeah, I was right. Washington Post High School. Okay, so the Reno Gazette Journal published a Washington Post High School challenge. And in here, Reno's Choral Academy leaps to number 2 status in the state in Washington Post School Challenge. So that's really cool. Now I know where I got this from. It's difficult to read, so I'm not going to read through it. And at the same time, the judge reads it into the record anyway. So you're going to get to hear about this at the hearing. And I feel like this really made a big impact on the judge's decision to order our son to go to choral. Exhibit 4. Schedule of arrearages. These are what my ex owes in child support. Again, we're going to get this resolved later on in my docket series, not at the hearing. Exhibit 5. Memorandum of costs. I don't even know why I attached these. Exhibit 6. What is this here? Enrollment. Oh, this is the email probably indicating that I sent this to my... Yeah, I did. This is the email that I sent to my ex's attorney with both of the PDFs attached to it. So this is just me showing the court that I turned documents over to my ex's attorney as is required by the rules. Probably the same thing here. And that's the end of that. Notice of appearance. So here goes the attorney, Clifton Young. He's a Reno attorney. And he is just indicating to the court that he is going to appear on my behalf as counsel of record, and he's going to represent me. Certificate of mailing indicates that he mailed this document to my ex's attorney to let her know that I am represented now. A supplementary exhibit to petitioner's hearing statement. So when I talked to the attorney, he took a look at my file, and he was pleased with the work I had done, but he wanted one more thing to be included in what we were going to discuss at the trial. I really appreciate him pointing this out to me, but he apparently is used to these types of disputes, these disputes between schools, and one of the things that he's mentioned the judges like to see is a kind of diagram that indicates how far the proposed schools are from the parents' homes. And I believe that's what he's saying here. He identifies himself as my attorney, that he is representing me, that he wants to provide a supplementary exhibit to the court, well, to my hearing statement, basically. And he is indicating, or at least his paralegal is indicating, that she mailed the particular document to my ex's attorney. We got Exhibit 1, which is the Coral Academy of Science Accountability Report. I don't remember this being right. I didn't think this was it, though. What is he talking about here? Oh, okay, so I was thinking it was some kind of document. Okay, so he does eventually turn something over that shows the distance between the two schools. I for sure remember this distinctly being faxed to my ex's attorney. So maybe he just provided that to her, off the record. And it was never an issue when we went to court. The court did consider the distances between us and the schools. Okay, so what he needed me to include was Coral Academy of Science's Accountability Summary Report. And I still appreciate him mentioning this because I included Roland's, but I didn't include Coral Academy of Sciences. I don't know why I didn't do that. Maybe I just overlooked it. Maybe I meant to do it and I forgot. I don't know. But like the other one, I'm going to just glaze through this because it's going to come up at the hearing and it's going to be more impactful, I think, on my viewers than to go through this thing one by one. So, going into the aftermath, I filed all three of those documents, and I incurred $0 in costs. They were all free filings. My ex-attorney didn't file anything, so she incurred $0 in costs. I did have an attorney for 2 of those documents, but he represented me for free, so I incurred $0 in attorney fees. My ex's attorney would have probably spent 5 minutes. It's hard to say with that supplementary because she might have actually reviewed that carefully. I'm going to go ahead and say 10 minutes for both the notice of appearance and the supplementary exhibit, and I'm going to say 20 minutes for my hearing statement. It does contain some pretty important details with regards to my position, as I'm going to go into court and argue for those. Not only does it have my position, but it also has supporting case law and authority. I think that, and plus there's still the fact that my ex's attorney has to communicate with my ex. So it's not just preparing the document. At some point, there's going to be a few emails, maybe a phone call, maybe even an in-person sit-down to really quickly go over some of these details that are going to come up. It's not always just that she just files these things into her computer system and doesn't even call my ex. I think there is a little bit of dialogue, at least a little bit going on. So 20 minutes plus the 10 minutes comes to a total of half an hour at the rate of $250 an hour. That's going to come to $125 in attorney fees for my ex. As with my previous videos, if you have any questions, feel free to post them down in the comments below, and I will see you guys next time.